When a federal judge orders the arrest of a former president of the United States and the Supreme Court intervenes within hours, what exactly is just broken inside the American system? At first glance, this looks like another chapter in a long-running political drama. Another headline, another escalation, another clash in an already polarized era. But that interpretation misses the institutional gravity of the moment. What we are witnessing is not simply a dispute over one man. It is a direct collision between the judiciary and the highest office in the executive branch, now pulled into the orbit of the Supreme Court itself. The very mechanisms designed to interpret and enforce the law are now straining against one another. In more than 2 centuries of constitutional history, the United States has never seen a former president ordered arrested by a federal judge while simultaneously seeking emergency protection from the nation's highest court. That rarity is not accidental. The framers of the Constitution feared this kind of confrontation. They built a system of separated powers precisely to prevent any branch from dominating the others. But they also assumed a level of restraint, of shared commitment to institutional stability. Here lies the paradox. The courts exist to resolve disputes peacefully under law. Yet now, the lower courts and the Supreme Court appear locked in a struggle over authority itself. There is no clear constitutional blueprint for how this conflict should unfold at this speed under this level of political pressure. Most people watching this story are focused on Trump, but the deeper issue is whether the constitutional architecture of the United States can withstand a crisis it was never fully designed to manage. To understand why the Supreme Court moved so quickly, we need to look carefully at how this confrontation began. The sequence of events that produced this constitutional confrontation did not unfold slowly. It accelerated with a speed that itself reveals something important about the institutional pressures now driving the American legal system. At the center of the immediate crisis is a federal judge's determination that existing legal proceedings had reached a threshold requiring enforcement, that the mechanisms of accountability already in motion could not be allowed to stall indefinitely. The judge, operating within the established authority of the federal judiciary, issued an order that crossed the line no American court had previously crossed in the modern era. The order demanded the physical compliance of a former president with the court's directives, backed by the implicit authority of arrest. Trump's legal team responded within hours. Not through standard appellate channels, which operate on timelines measured in weeks or months, but through an emergency application, one of the rarest instruments in the entire American legal architecture. Emergency applications to the Supreme Court are reserved for moments when the normal pace of litigation would itself cause irreparable harm. They bypass the usual procedural layers entirely. The fact that this mechanism was invoked tells you something critical. The people closest to this case understood immediately that allowing the arrest order to proceed, even temporarily, would generate consequences that no subsequent ruling could fully undo. The institutional actors now positioned at the center of this crisis each carry enormous weight. The federal judge represents the principle that judicial orders must be enforceable against anyone. The Supreme Court justices reviewing the emergency application carry the responsibility of deciding whether that principle has limits when applied to a former president. The Department of Justice occupies an uncomfortable middle position, simultaneously an instrument of executive authority and a guardian of legal process. Trump's defense team is arguing not merely for their client, but for a doctrine that former presidents retain constitutional protections that place certain actions beyond ordinary judicial reach. That doctrine did not emerge from nowhere. The Supreme Court had already been expanding its interpretation of presidential immunity in recent years, most significantly in its 2024 ruling establishing that former presidents hold substantial immunity for official acts. This intervention fits within that trajectory. The speed at which this crisis reached the nation's highest court tells you that the people inside these institutions recognized immediately that something structural had fractured. But understanding exactly what fractured and why requires looking much further back than this single confrontation. The American Constitution is a document of remarkable precision in some areas and remarkable silence in others. The framers defined the structure of government with considerable care. They were far less precise about what happens when that structure turns against itself. On the question of executive accountability, the silence is deliberate. The framers were deeply familiar with the dangers of unchecked executive power. They had lived under a monarchy and fought a revolution to escape it. But they were equally afraid of a system so constrained that it could not function under pressure. The result was a constitutional design that separated power across 3 branches, established checks and balances, and then left the precise mechanics of interbranch conflict largely unresolved. The assumption was that shared values, political restraint, and institutional respect would fill the gaps the written text left open. That assumption has been eroding for decades. The first serious test came during the Nixon era. When the Supreme Court ruled unanimously in United States v. Nixon in 1974 that the president could not withhold subpoenaed evidence by claiming executive privilege, it established a foundational principle: a sitting president is not above the law. But that ruling left an important question unanswered. Nixon resigned before criminal prosecution became a serious institutional reality. The question of whether a sitting or former president could actually be indicted, tried, and imprisoned was never fully resolved in court. It was resolved instead through political accommodation, a presidential pardon, a resignation, a system that chose institutional stability over complete legal accountability. The precedent was established in principle but never tested to its limit. Clinton v. Jones in 1997 pushed the boundary further. The Supreme Court ruled that a sitting president could face civil litigation for actions taken before assuming office, rejecting the argument that the demands of the presidency placed the office entirely beyond civil judicial reach while in power. It was another affirmation that the presidency carries no absolute legal immunity. But again, the ruling was carefully scoped. It addressed civil liability for private conduct before taking office. It did not resolve the deeper question of criminal accountability for actions taken during or in pursuit of the presidency itself. Each of these rulings established important principles while simultaneously leaving the most difficult questions for a future confrontation. That future confrontation arrived with the Supreme Court's 2024 ruling in Trump v. United States. The court established that former presidents hold substantial immunity from criminal prosecution for official acts taken while in office. It was the most significant expansion of executive protection in the court's modern history. But the ruling contained a structural problem that its critics identified immediately and its supporters largely dismissed. The boundary between official and unofficial acts was left deeply ambiguous. The court acknowledged the distinction was critical, but provided no precise framework for applying it consistently. That ambiguity was not an oversight. It reflected the genuine difficulty of drawing a clean line. But it also guaranteed that the question would return in a future case under a future set of facts with higher institutional stakes. What most coverage of this crisis misses is the longer pattern. Each major judicial confrontation with executive power over the past 50 years has raised the institutional stakes for the next one. Each incomplete resolution has left a structural gap that future actors could exploit or fall into. The Supreme Court did not create this crisis through its emergency intervention. The crisis was assembled gradually through decades of precedents that established important principles without resolving the deeper tensions between them. The intervention was simply the moment the accumulated pressure became publicly visible. Other democracies have faced comparable moments. France's Fifth Republic built explicit presidential immunity directly into its constitutional text, choosing institutional protection over legal equality. South Korea prosecuted and imprisoned multiple former presidents, demonstrating that accountability was possible, but also that it carried serious costs to institutional stability. Neither model translates cleanly to the American context. But both illustrate that how a democracy resolves the tension between executive accountability and institutional stability shapes its political character for generations. America is now being forced to make that determination in real time under maximum pressure, with the entire world watching, understanding that history makes the current crisis legible. But history alone cannot explain what every actor in this drama is actually trying to achieve, and that calculation is where the real story lives. What looks like a legal dispute is actually something considerably more complex. Beneath the surface of courtroom orders and emergency appeals, at least 4 separate strategic games are being played simultaneously, each with its own logic, its own stakes, and its own long-term consequences. Understanding this crisis requires examining each layer with the seriousness it deserves. The first strategic game belongs to the federal judiciary, and it is more precarious than most observers have recognized. When the judge issued the arrest order, the ruling was not simply a legal determination. It was also an institutional assertion, a statement that the authority of federal courts to enforce their orders extends to anyone within American jurisdiction, regardless of their former office or current political standing. Courts derive their power not from armies or budgets, but from the assumption that their rulings will be respected and enforced. That assumption is the foundation of the entire judicial system. Every time a court issues an order, it is implicitly staking its institutional credibility on compliance following. When the Supreme Court intervened at emergency speed, the implicit signal sent downward through the judicial hierarchy was deeply uncomfortable. The lower court had moved into territory the highest court was not prepared to ratify without extraordinary review. That signal, whatever its ultimate legal justification, carries a structural cost. If emergency Supreme Court intervention becomes a reliable mechanism through which sufficiently powerful defendants can suspend lower court enforcement, the authority of the entire federal judiciary below the Supreme Court level is quietly but meaningfully diminished. Judges across the country will register that lesson, whether anyone states it explicitly or not. The second strategic game is the one the Supreme Court itself is now forced to play, and it may be the most consequential. The court faces a calculation with no clean exit. Consider both directions honestly. If the justices allow the arrest order to proceed and a former president is taken into custody, the immediate consequences are almost impossible to fully anticipate. The political shock would be without modern precedent. The institutional turbulence, public reaction, potential civil unrest, international perception, market instability would test the resilience of American democratic culture in ways that no legal ruling could fully prepare the country for. The court would be blamed by a significant portion of the public for enabling what they would characterize as the weaponization of the judiciary against a political figure. Its legitimacy, already under sustained pressure, would face a new and serious challenge from that direction, but the alternative carries equal institutional danger. If the court blocks the arrest order, if it effectively establishes that a former president cannot be compelled to comply with a federal judge's enforcement mechanism, it sends a different but equally damaging message. It tells the American public and the watching world that the principle of equality before the law has a ceiling, and that ceiling is low enough for a former president to stand comfortably beneath it. That conclusion would damage the court's legitimacy just as severely from the opposite direction. The justices understand this. Their decision is not purely a legal calculation. It is an institutional survival calculation, made under conditions where every available option carries significant damage to the court's long-term authority. The third strategic layer operates on a longer timeline and is arguably the most structurally important. This crisis is not an isolated event. It is the latest and most acute expression of a decade-long trajectory in which executive power claims have expanded, congressional oversight has weakened, and the boundaries of judicial authority have been increasingly contested. The structural incentives driving this trajectory have not changed. If this crisis results in a further expansion of presidential immunity, the boundaries of executive protection will have been extended once more, and future presidents of any party will inevitably test those extended boundaries. Political institutions, like all human systems, tend to push against their constraints until they find a limit that holds. If immunity expands, the next limit will be tested. If, alternatively, this crisis results in a curtailment of immunity, future administrations will not simply accept that outcome passively. They will find alternative mechanisms, procedural, political, institutional, to resist judicial authority in ways that may be more difficult to challenge directly. The structural incentive toward further escalation does not disappear with a single ruling. It simply finds a new channel. The fourth strategic layer is the one that most mainstream coverage consistently underweights, and it may ultimately be the most dangerous. American democratic institutions were never designed to operate on written rules alone. The Constitution establishes a framework, but the framework always depended on something the document itself cannot mandate. The willingness of political actors to honor the spirit of the system, even when violating its letter, might be advantageous. These informal norms, the voluntary restraints, the mutual institutional respect, the shared commitment to the stability of the overall system over the short-term gains of any individual actor, function for generations as the invisible architecture holding the written Constitution together. What this crisis reveals with uncomfortable clarity is that this invisible architecture has been significantly degraded. The written rules are now being asked to carry a structural load they were never designed to bear alone, and they are visibly straining under the weight. When informal norms erode, formal institutions are forced to adjudicate conflicts that the system previously resolved through restraint and convention. The result is exactly what we are now witnessing, an escalating series of institutional confrontations, each one more acute than the last, each one leaving the participating institutions slightly more damaged than before. The strategic reality that most coverage is not stating directly is this: the Supreme Court does not have a good option. Every path forward damages something important and does so in ways that will outlast this immediate crisis by decades. Foreign governments are watching this confrontation with a mixture of concern and, in some capitals, undisguised strategic interest. American allies are quietly reassessing what the visible fragility of these institutions means for the reliability of American commitments. Adversaries are cataloging every signal of institutional weakness for future use. The choice the court makes will not simply determine the immediate legal fate of one former president. It will define the boundaries of American executive power, the enforceability of judicial authority, and the credibility of the rule of law principle for the foreseeable future. The consequences of that choice extend far beyond the institutions now making it, and understanding those consequences requires us to look outward at what this moment changes not just for America, but for its position in the world. If you think the consequences of this crisis end at the courthouse door, you are significantly underestimating what is actually at stake. The immediate legal confrontation is real and serious, but it is the outermost layer of a much deeper set of consequences that will reshape American institutions, global perceptions, and economic calculations long after the specific legal questions are resolved. Begin with the most immediate ring of consequence, the simultaneous credibility crisis now engulfing all three branches of American government. This is not a situation where one institution is weakened while the others remain stable. The federal judiciary's authority is under question. The executive branch's relationship to legal accountability is actively contested. The Supreme Court's legitimacy is being tested by a decision it cannot make cleanly. When all three branches are visibly strained at the same moment, the damage to public trust is not additive, it is compounding. Americans who already held diminished confidence in their institutions are watching those institutions fight each other in real time over the most fundamental question a democracy can face. Decades of polling data on institutional trust in America show a long, consistent decline across the judiciary, Congress, and the executive branch. Acute crises like this one do not simply reflect that decline, they accelerate it. And trust, once lost at scale, is extraordinarily difficult to rebuild. The constitutional architecture consequences run even deeper. The American Constitution did not anticipate this precise configuration of interbranch conflict. It established separation of powers and provided mechanisms for some forms of institutional dispute. But it left no clear agreed-upon process for resolving a direct confrontation between a federal court's enforcement authority and a former president's claim to constitutional protection, particularly when that confrontation reaches the Supreme Court under emergency conditions. Whatever ruling the court issues will therefore function as something more than a legal decision. It will effectively write new constitutional rules governing the relationship between executive accountability and judicial authority for all future presidencies. That is an enormous amount of constitutional weight to place on a single ruling produced under emergency pressure, without full briefing, without extended deliberation, and in the middle of a politically charged environment that makes neutral analysis nearly impossible to perform or perceive. The geopolitical consequences extend the damage outward into the international arena, and this is the dimension that most domestic coverage consistently underweights. America's global influence has never rested on military power alone. It has rested substantially on the credibility of its institutions, on the perception that American democracy, whatever its imperfections, operates within a stable framework of law that constrains even the most powerful actors. That perception is a form of soft power, and soft power is genuinely strategic. China's state media apparatus has already demonstrated a consistent pattern of amplifying American institutional failures as evidence that liberal democracy is structurally unstable. Russia's information environment similarly uses American political turbulence to justify its own authoritarian model domestically and internationally. When America's Supreme Court and federal judiciary are visibly in conflict over whether a former president can be arrested, those governments do not need to fabricate a narrative. The situation provides one directly. Meanwhile, American allies in Europe and Asia are engaged in their own quiet reassessments. The question they are asking is not primarily about Trump. It is about whether American institutions can be relied upon as stable anchors for the international relationships and security commitments that have defined the post-war order. The economic dimension completes the picture. Constitutional crises generate institutional uncertainty, and markets price institutional uncertainty as risk. International investors treat the health of American democratic institutions as a long-term indicator of economic reliability. When those institutions are visibly under stress, the signals that reach financial markets, currency valuations, and long-term investment planning are ones of elevated instability. The consequences of this crisis are real, measurable, and expanding outward in every direction. But whether they represent a temporary rupture or a permanent structural fracture depends entirely on what happens next. The goal here is not prediction. The situation remains fluid, the legal questions genuinely contested, and the institutional pressures pulling in multiple directions simultaneously. What is possible, and what serious strategic analysis requires, is an honest mapping of the realistic scenarios now in play and a clear-eyed assessment of what each one means for American institutions, democratic stability, and global standing. The first scenario is the one that current legal trajectory makes most structurally plausible. The Supreme Court issues a ruling that permanently blocks the arrest order, effectively extending the presidential immunity doctrine established in its 2024 ruling into new territory. The institutional consequences of this outcome are significant and lasting. Lower court enforcement authority over former presidents is meaningfully curtailed. The protected boundary around the executive office expands further, establishing a precedent that every future president will understand and that future legal teams will cite. The political backlash from those who believe the ruling places powerful figures beyond the law's reach will be immediate and sustained. But the deeper long-term consequence is subtler. Once the Supreme Court establishes a ceiling above which judicial enforcement cannot reach, the question immediately becomes where exactly that ceiling sits, and future actors will spend years testing its precise location. Resolving one confrontation by expanding immunity does not end the underlying tension, it relocates it. The second scenario produces the most immediate institutional shock. The court declines to intervene, allows the arrest order to stand, and a former president is taken into custody. The rule of law principle is visibly affirmed in its most demanding application. But the consequences that follow are not straightforward. The political turbulence, potential civil unrest, and institutional strain generated by enforcement of this magnitude would test American democratic resilience in ways that extend well beyond the legal question itself. International allies would register the outcome as evidence that American institutions can enforce accountability at the highest level, a genuine soft power signal. But adversaries would simultaneously amplify the domestic turbulence as evidence of systemic instability. Whether this scenario ultimately strengthens or further strains the rule of law depends heavily on whether American institutions can manage its aftermath with the stability and restraint the moment would demand. The third scenario is the one most institutionally tempting and most strategically deceptive. The court issues a narrow ruling that temporarily suspends enforcement while ordering further review of the underlying constitutional questions. It is the compromise outcome, the path that avoids the immediate crisis without fully resolving anything. Its appeal is obvious. It reduces the immediate institutional shock, buys time for more deliberate legal analysis, and allows the political temperature to drop. But its hidden cost is equally significant. Delayed resolution is not neutral resolution. Every month, the fundamental constitutional question remains unanswered. The uncertainty it generates continues to damage institutional credibility, erode public trust, and invite further escalation from actors who read ambiguity as opportunity. Compromise outcomes in institutional crises frequently feel like relief in the short term and reveal themselves as postponements of a harder confrontation in the medium term. The fourth scenario is the one receiving the least serious attention and deserving the most. Not a dramatic resolution in either direction, but a prolonged period of legal contestation, political entrenchment, and institutional paralysis in which nothing fully resolves and everything slowly deteriorates. Each branch holds its position. Public trust continues its downward trajectory. The informal norms that might once have generated a voluntary de-escalation do not regenerate. History provides uncomfortable guidance here. Democratic systems rarely fail suddenly. They erode gradually through the accumulation of unresolved institutional conflicts, declining public confidence, and the slow normalization of confrontations that previous generations would have considered unthinkable. Hungary, Turkey, and Venezuela each followed versions of this trajectory. Not sudden collapses, but incremental degradations that became irreversible before most observers recognized the pattern. Each of these scenarios carries its own long-term weight, but across all of them, one central question persists. The question this entire crisis ultimately forces America to confront directly. We began with a single question. When a federal judge orders the arrest of a former president and the Supreme Court intervenes within hours, what exactly has broken inside the American system? Having examined the history, the strategic calculations, the institutional consequences, and the realistic scenarios ahead, we are now in a position to answer that question honestly. What has broken is not primarily a legal mechanism. Legal mechanisms can be repaired through rulings, legislation, and constitutional amendment. What has broken, or more precisely, what has been revealed as already broken, is the informal architecture that the written Constitution always depended upon but never fully specified, the norms of mutual institutional restraint, the voluntary commitment to the spirit of the system rather than the exploitation of its letter, the shared understanding among political actors that the stability of the overall framework matters more than the short-term advantages available to any individual within it. These informal guardrails do not appear in a constitutional text because the framers assumed they would not need to. That assumption has proven fragile in ways the framers feared but could not fully prevent. The deeper paradox at the center of this crisis deserves to be stated plainly. The institutions now fighting over how to enforce the rule of law are, through that very fight, damaging the rule of law itself. Legal systems derive their authority not merely from the correctness of their rulings, but from the public perception that those rulings emerge from a process that is stable, neutral, and genuinely above political calculation. When that perception fractures, and it is fracturing now, simultaneously across multiple institutions, the legal system loses something that no subsequent ruling can fully restore. Legitimacy is not a legal concept, it is a social one. And social trust, once broken at scale, rebuilds slowly, if it rebuilds at all. The framers were brilliant constitutional architects, but they were also realists who understood that architecture alone cannot sustain a republic. The system they designed was always meant to be maintained, actively, deliberately, and continuously, by the generations who inherited it. What this crisis reveals is that when institutional actors begin optimizing for their own survival, rather than for the health of the system they inhabit, the Constitution cannot save the republic by itself. That work has always belonged to the citizens and institutions who choose every day to make it function. This crisis will eventually find some form of resolution. But the question it leaves unanswered will not resolve with any single Supreme Court ruling. It belongs to all of us, and the answer is being written right now.